Welcome to the 2021 Call for Papers virtual luncheon. I appreciate people for checking in and watching us. And certainly I appreciate our three winners this year who wrote papers that were selected by our committee as the top papers submitted to the Call for Papers presentation. Each year we host usually a luncheon. This is our second year we're doing it virtual because of the virus issue. But we plan to be back in full stride next year. We do have a host this year, a sponsor, I should say, that I would like to tell you a little bit about, play a little video from them. And we certainly thank the GRE people for sponsoring our program. I don't know if I introduced myself when I started. I'm Ron Rychlak. I'm a professor at the University of Mississippi School of Law. I'm also former president of SEALS, so I've been involved in the organization for a long time. And this is a great organization, and we certainly appreciate all of our sponsors, including GRE, which I took the GRE after college, but ended up going to law school with the LSAT. Today, we have three papers that will be presented, three speakers, and I'm going to go ahead and introduce them now, introduce their papers a little bit, just who everyone is, and we'll have discussion perhaps later on. But our first speaker will be Andrew Hammond from the University of Florida, Fredric G. Levin College of Law. His paper is on territorial exceptionalism and the American welfare state. Our second speaker will be Leandra, Lederman, Indiana University Maurer School of Law. Her talk is on the fraud triangle and tax evasion. And then Professor Jamie MacLeod from Brooklyn Law School will be speaking on finding original public meanings. If we were in person, I'd have the opportunity to present this to each one of our panelists. Today, I'm just going to hold up as an example. This is the plaque that each one will receive. This is actually Andrew's one, but the other two have been mailed ahead to our winners. But it's a very nice thing to put on your wall. I never got one. It's a nice thing to have on your wall, and it does reflect the sincere respect of all. But with no further ado, I will go ahead. That was Andrew's award, and we'll let Andrew kick us off by talking about your paper.
Thanks so much, Ron. Thanks, everyone, for listening to my talk and listening to Leandra and Jamie present as well. I really want to extend my appreciation to Ron and the committee who reviewed the papers as part of this competition, and to SEALS. And I'm really delighted and honored to be in Leandra and Jamie's company. So for those of you who don't know my work, basically half of my research agenda is about bringing poverty law into the 21st century and really adapt how the ways in which the American welfare state should adapt given kind of contemporary and future challenges. And so for the last few years, I've been working on a series of papers, mainly law review articles, but some book chapters as well, really taking the Welfare Reform Act from 1996 as a starting point and thinking through the implications of kind of existing federal and state law as it relates to certain programs, but also to certain populations like immigrants, the role of lawyers and state bureaucrats in the implementation of these programs. And the paper that I'm going to talk about today and that I submitted to the competition is the latest published paper in that. I have kind of one other paper that I have in mind that I've been spending the summer working on, which is really trying to center and focus attention on the experience of Americans in the 5 territories. So Puerto Rico, Guam, American Samoa, the Commonwealth of the Northern Mariana Islands, and the US Virgin Islands. And so this article's published by Michigan Law Review, is just published a couple weeks ago. And essentially, I can sum up this paper in one sentence, which is that federal law impermissibly excludes Americans who live in the territories from 3 of the most important public benefit programs: the Medicaid program, SNAP, which is formerly known as the Food Stamp Program, and Supplemental Security Income, the main means-tested disability assistance program. So to just get us started, I want to tell you a little bit about a case called United States versus Madero, which the First Circuit decided last year, but the Supreme Court has granted cert in this case. So the briefing will wrap up in September, and I'll just say that if you find my arguments persuasive, I have an amicus brief for you to sign that I'll be circulating in the Legal Academy in the next couple weeks. I have a draft behind me on my desk that I'm working through with Oric, which has been kind enough to help me with the amicus brief. So let me just tell you a little bit about this case. This case involves an individual by the name of Jose Luis Vayo Madero. He was born in Puerto Rico and is therefore a US citizen by birth. 30 years later, Mr. Vayo Madero moved from Puerto Rico to New York. And nearly 30 years after that, in 2012, Vayo Madero began to receive federal disability benefits through SSI. A year later, after starting to receive these disability benefits, Mr. Vayo Madero moved back to Puerto Rico. And a few years after that, the Social Security Administration informed him that it would discontinue his SSI benefits dated retroactively to his return to the island. And in its notice, the agency stated that Mr. Vayo Madero, and I'm quoting here, had been, quote, outside of the US for 30 days in a row or more since 2014. And the agency noted that, quote, it considered the US to be the 50 states of the United States, the District of Columbia, and the Northern Mariana Islands, end quote. Obviously, Puerto Rico has been a United States territory for 122 years, but the Social Security Administration's definition of the United States excludes Puerto Rico. So roughly a year later, the United States sued Mr. Vayo Madero to recover the alleged improper disability benefits over that 2-year period. So they sought recovery of over $28,000. And an investigator employed by the federal agency got Mr. Vayo Madero, who was without counsel at the time, to sign a stipulated judgment, which the federal government promptly filed in federal court in Puerto Rico. Now, the district court appointed counsel for Mr. Vayo Madero, and counsel raised as an affirmative defense that excluding him and other Puerto Rican residents from SSI benefits violated the Constitution's equal protection guarantee. And on cross motions for summary judgment, the district judge agreed. And in April of 2020, the First Circuit affirmed, holding that excluding Puerto Rican residents from the SSI program violates equal protection. Now, the Supreme Court's going to get a chance to weigh in on this. But before I get into the more on the litigation, I really take this case as a kind of excuse to explain how Mr. Vayo Madero's exclusion from public benefits epitomizes the extent to which federal law places millions of Americans outside the welfare state. And it excludes American citizens from crucial benefits simply because they live in the territories. So residents of Puerto Rico, the Northern Mariana Islands, and American Samoa are excluded from the food stamp program. Instead, they receive block grants for assistance, which don't respond to a surge in need. So the territories get the same amount of money every year, regardless of what's going on, whether there's a hurricane or a COVID-19 pandemic or a recession. And as with food assistance, the federal government caps medical assistance for each of these territories. And this Medicaid cap does not exist for the 50 states or DC. So as Vayo Madero's case illustrates, as it relates to disability assistance, no American living in Puerto Rico can receive this program, whether because of age or disability. I'll just point out that for people who might not be interested in public benefits, these discrepancies in public benefits mirror the exclusion of territorial Americans in other areas of federal law. So an American who lives or who moves to the British Virgin Islands can vote in the presidential election via an absentee ballot, but if that person moves to the US Virgin Islands, they can't. American Samoans have an even stranger status. The State Department actually stamps their passports with a disclaimer that reads, quote, "The bearer of this passport is a United States national and not a United States citizen." Incidentally, last year, a federal judge disagreed with that, and the 10th Circuit is considering that challenge right now. So the bottom line is any inquiry into the public law that governs the US territories necessarily runs up against this persistent democratic deficit, but I don't think that this is these irregularities are simply fodder for academic debate. They really ensnare over 3 million Americans. I mean, 5 times as many Americans live in the territories than in DC, and roughly as many Americans live in the territories as those in Alaska, Delaware, Hawaii, and Wyoming combined. And while the federal government doesn't actually engage in systematic poverty measurement, in the territories. The data we do have on levels of poverty paints a stark picture. So the Census Bureau estimates that the poverty rate in Puerto Rico in 2018 was 43% compared to a national poverty rate of under 12%. Adults living in the US Virgin Islands are 2.5 times more likely to lack health insurance than those in the 50 states. And the level of poverty and deprivation is only going to worsen as the 5 US territories are particularly vulnerable to the ravages of the climate crisis. They're really on the front lines of climate change given their geographic positions. And so they're going to face increasingly tenuous living conditions due to extreme weather events made more frequent and more intense by a warming planet. And I kind of talk about that in the paper. Something else I just want to say about this paper is that I think there are a couple caveats in order. First, my article really risks eliding the different histories, politics, and social dynamics of these 5 territories. They have different constituencies and interests and agendas when it comes to the federal government. But I think by providing a comprehensive comparative analysis of federal law in this area, it shows that their treatment compared to states or even among themselves is difficult to justify, which for those of you who know equal protection is kind of the ballgame in the litigation. The only other caveat I'll say about this paper is that you should bear in mind that those who reside in these territories don't necessarily think American citizenship is an unalloyed good. And in this context and others, American citizenship has often been perceived as a weapon that the federal government can wield to stifle sovereignty and promote assimilation, kind of against the desires of people who actually live in these places. So what my article is doing is doesn't question whether the territory should have a different legal relationship to the United States, whether that's independence or something else, but instead really begins with the fact that most people who live in the United States territories today are American citizens, and then proceeds to focus on what are the social dimensions of these Americans' citizenship and what should it be. So I'll just move pretty quickly through the doctrinal background on the territories. By and large, I'd say the Legal Academy tends to relegate cases and controversies involving territories to the background of American public law. Some historians obviously have begun to discuss the United States through the analytic lens of settler colonialism, and some, thinking of Sam Ehrman here at USC, have sought to connect the Reconstruction struggle for full citizenship with the nation's fits and starts towards empire in Puerto Rico and elsewhere. Obviously, the kind of doctrinal background begins with the insular cases, which have been repeatedly excoriated as suspect and racist. And it's not a coincidence that 8 of the Supreme Court justices who decided Downs versus Bidwell, one of the kind of leading insular cases, one of the more infamous, also decided Plessy v. Ferguson. And the court's racist language in these cases really rhymes with its Jim Crow decisions. It characterizes the people of Puerto Rico as, quote, an alien race differing from us in religion, customs, laws, methods of taxation, and modes of thought. And it says that they're basically incompatible with Anglo-Saxon principles. As Christina Ponce-Krauss at Columbia has put it, the insular cases really rendered, I lost my notes. It rendered the territories essentially invisible, neither fully domestic nor fully foreign. And so members of the territories, they can't participate fully in the political life of the country with voting representation in Congress. And then the Supreme Court doctrine has really robbed them of the full benefits of American citizenship. So the statutory background on these programs in the paper, I go through in detail the kind of technical aspects of the statutes for Medicaid, food stamps, and SSI. I don't have time to here. I'll just tell you the kind of upshot of this is that if you look at the state of play of federal law, really no territory has the kind of default standard financing arrangement in food, medical, or disability assistance compared to the states. So, Guam has access to the food stamp program, the Northern Mariana Islands have access to SSI, but pretty much every territory is excluded from Medicaid, because of this cap that I mentioned earlier, and only a couple will have access to the food stamp program and SSI. And as I document in the paper, this has real consequences for Americans who live in these places. The benefit levels are lower. That's not surprising because they get less funding. And so when a hurricane hits or there's a huge recession or a pandemic, the territorial governments don't have the financing necessary to meet the levels of need. A very dramatic example of this is that Puerto Rico ran out of its food assistance funding 6 months into the fiscal year after Hurricane Maria, because it spent a ton of funding, all of its funding to meet the need after that terrible storm. So my article proceeds to look at how this status quo is being challenged in both courts and Congress. And I really take advantage of the fact that there's been a significant amount of litigation and legislation in the last 2 or 3 years. So in a series of, let me talk about the litigation first. In a series of recent lawsuits, Americans living in the territories basically challenged the status quo of their second-class citizenship, and they've done so on various issues, including voting rights and birthright citizenship, not just on public benefits. Bio Madero being one of them, but there's an interesting class action that was filed in the district court in Puerto Rico, which challenged the exclusion from SNAP, SSI, the Medicare Part D subsidy. So it's in some ways more ambitious litigation. Obviously, it's going to kind of live or die on the basis of what the Supreme Court does with Bio Madero. And then there's another case involving someone in Guam's access to SSI as well, which is working its way through the district courts in Pennsylvania and could very well end up in the Third Circuit. In the paper, I explain how existing equal protection doctrine and the right to travel doctrine have not been that conducive to these kinds of challenges. The Supreme Court relies and lower federal courts rely on 2 per curiam decisions, the Califano versus Gautier Torres case and Harris versus Rosario. These were decided decades ago. There's very thin reasoning, but the government is relying on that in its briefs in the Bio Madero case, and courts have used that to strike or to be kind of refuse to entertain these types of challenges. I actually think Bio Madero has a strong case for reasons I can't really go into here, but I think if you look at the government's briefing, they have a really tough time defending the rationale for excluding some territories from some programs and not others. That said, even though I kind of take the litigation seriously in the paper and I'm interested in weighing in through amicus briefs, I really think that this is a job for Congress. The traditional judicial deference afforded to Congress when it comes to the territories, really dating back to the insular cases, but even before that, means that it would mostly likely have a free hand to end territorial exceptionalism in the American welfare state. And so in the paper, I explained that Congress has actually been quite active in this area, but they've really been active in the context of emergency aid. So President Obama in the 111th Congress, when they enacted the 2009 stimulus bill, the ARA legislation, they actually made significant increases to SNAP, which included Guam and the US Virgin Islands, but they also temporarily increased food assistance for Puerto Rico and American Samoa. And Congress also increased the cap on Medicaid reimbursement to all 5 territories. Congress has also had to confront several extreme weather events over the last 5 or 6 years. And as I said, the territories are particularly vulnerable to these. Congress has been willing to appropriate additional funding to the territories following these devastating storms, but obviously there's a limit to this kind of emergency appropriation. Additional food assistance funding for Puerto Rico stalled in 2019 and in 2020, and the Trump administration actually referred to this additional proposal as excessive and unnecessary. And so Puerto Rico, as a result, had to cut their food assistance spending by $100 million per month. And then the only other thing I'll say about this kind of emergency aid, which you see on the slide, is that Congress has been pretty active in the COVID-19 pandemic in increased spending and increased eligibility for public benefits programs across the country, and they haven't forgotten about the territories. So they've provided time-limited supplemental federal Medicaid funds to the 5 territories, and notably, when it came to the pandemic unemployment assistance, what some people talk as the UI extension, they actually included all the territories. And same with the pandemic EBT, the school meal funding. So I think this legislative activity suggests that there's an appetite in both houses of Congress for additional support for food, health, and disability assistance. I've been talking to Hill staffers in both houses actually about potential legislation. But I really think that the way to do this is not through emergency appropriations, but through a structural fix. And at the end of my paper, I actually lay out how Congress could engage in more ambitious legislation and incorporate the 5 U.S. territories into the existing statutory framework for SNAP, Medicaid, and SSI. And the thing I'll just conclude with and leave you with here is that I began this work focused on how federal law disadvantages Americans who happen to live in the U.S. territories. But and one way of thinking about this is that in this area of federal law and others, territorial Americans are outsiders. But as I kept doing this research, I started to think, well, what if their outsider status is not an outlier? What if their experience is, in another sense, the kind of quintessence of social protection in the United States? And another way of thinking about this is the experience of Americans in the territories, yet one more example in which the American welfare state is kind of predicated as a racial order. So if you start to look at how Americans in the territories access these programs, how Black Americans access these programs, how immigrants are excluded from eligibility in a lot of these programs, and then Indigenous Americans as tribal members are often left out of these programs as well. I think it starts to change how we think about existing federal law more broadly. So thank you for listening. I encourage you to read the paper. And like I said, if you find the paper persuasive, I've got a brief for you to sign.
Thank you, Andrew. That was great. And you see why I was actually talking at lunch yesterday about why I like this committee, because it's not a paper I might naturally pick up in my normal research and such. And yet it's so informative, and it gets you thinking about, well, what is the appropriate status of a territory as opposed to a state? What does this mean in terms of a territory seeking statehood? All these issues, but becoming great focus in your paper. And we'll have a chance to have maybe a little discussion among the 4 of us after everyone else is presented. But I think we'll go ahead now and let Leandra give her presentation.
Thanks so much, Ron. It's a pleasure to be here at the SEALS Call for Paper panel. So I wanted to thank the committee for selecting my paper, and it's a privilege to be presenting today along with my co-panelists. I'm Leandra Lederman, the William W. Oliver Professor of Tax Law at Indiana University Maurer School of Law, and the paper that I'm presenting is The Fraud Triangle and Tax Evasion. And the article is in print now. It was recently published in the Iowa Law Review. So I'll give you some background on the project. It grew out of research for an article that I published in BYU Law Review in 2020 called Information Matters in Tax Enforcement. And that article is co-authored with one of my former students, Joe Dugan. That article responds to an article by Canadian law professor Wei Shui, who argued that information, particularly third-party information reporting, such as a W-2 or 1099 form, isn't critical to tax enforcement. He argued instead that what does matter is that firms which issue those information reporting firms are honest, they're pro-social, and that it's the presence then of the firm as a third-party reporter that's key to tax compliance. I've written a number of articles on various aspects of tax compliance and evasion, and my read of the literature is quite different. It's that third-party information reporting is very important to tax enforcement, so I felt I needed to reply to Shui's article. And my co-author and I framed our reply around the 2 strands of Shui's argument, one on third-party reporting and the other on what he argues is the pro-social or honest nature of corporations and other firms. So in researching firm honesty and the frequency of corporate malfeasance, I ran across the fraud triangle. And I was really surprised never to have seen it in the very extensive tax compliance literature. Now, in my research, I found that the fraud triangle has been applied in the tax evasion context before, but in brief treatments, generally by accountants, not law professors, not linked to the tax compliance literature. So I saw more to be done. And ultimately, my article is as much about the fraud triangle as it is about tax evasion. So in the first half, I address some misconceptions about the fraud triangle. And in the second half, I focus on how the triangle can add to the tax compliance literature. In the rest of my talk, I'll do three main things. I'll introduce the fraud triangle theory and describe it. I'll apply the fraud triangle to tax evasion, and I'll propose some implications for the tax compliance literature. So Donald Cressy's work in the early 1950s is typically credited as the origin of the fraud triangle, often with Edwin Sutherland's work as its antecedent. And Sutherland spent the last 15 years of his career as a professor at Indiana University, coincidentally. He coined the term white-collar criminal in a 1939 speech to the American Sociological Association. Sutherland was seeking to overcome a common understanding of crime as committed overwhelmingly by members of the quote-unquote lower class. And Sutherland also advanced the theory that criminality was learned behavior rather than due to personal characteristics. And Donald Cressy was one of Sutherland's PhD students at IU. And in Cressy's PhD dissertation and later his book, he sought an explanation for why, quote, some persons in positions of financial trust violate their trust, whereas other persons, or even the same person at a different time, in identical or very similar positions, do not violate it, unquote. And Cressy's project involved interviewing incarcerated men who had been convicted of embezzlement or a similar trust violation. He used the technique of analytic induction to develop a set of postulates that he found none of his cases falsified. And he ultimately found three factors common to individuals who became embezzlers or similar trust violators. His three factors were: one, a non-shareable pressure, generally financial; two, a perceived opportunity to embezzle; and three, rationalization of the planned violation. His first factor, a non-shareable financial pressure, involves something embarrassing to the individual, such as a gambling debt or failure of one's business. And of Cressy's three factors, this is the one that's undergone the most change over the years as the fraud triangle evolved. Cressy's second factor involves the perceived opportunity to commit the trust violation. And Cressy argued that it wasn't simply holding the position of trust, but also perceiving the opportunity to convert entrusted funds for one's own use. And the third Cressy factor is rationalization of the behavior as somehow acceptable, a mental verbalization of the planned act as somehow not really criminal. And Cressy argued that that rationalization occurred before the violation, allowing it to occur. The current fraud triangle factors, by contrast, are generally understood to be those described in US and international auditing standards. So fraud, whether fraudulent financial reporting or misappropriation of assets, involves incentive or pressure to commit fraud, a perceived opportunity to do so, and some rationalization of the act. And these standards were adopted in the early 2000s. So with respect to the first prong, incentive or pressure, the accounting standards describe it as generally financial. The statement regarding perceived opportunity for fraud points to an individual's ability to override internal controls. And the standards describe the rationalization prong as either relating to personal characteristics of the individual or resulting from a pressure-filled environment. Now, a 2008 article in the accounting literature by Donegan and Gannon found, quote, problematic the generalization from a sample of embezzlers to those who have committed financial statement fraud. Fraud and embezzlement are not identical crimes, but Cressy's factors were not simply carried over to the accounting standards. So here's a comparison of the factors. The opportunity prong is the same, but the other two differ. Cressy's factors are on the left, the accounting standards there are on the right. And these factors evolved over time. I suggest in the article that studies by CPA Steve Albrecht and his co-investigators for a KPMG report in the late 1970s, as well as a report by the National Commission on Fraudulent Financial Reporting, known as the Treadway Commission, in the late 80s, contributed to this evolution. So Cressy's factors were not simply carried over to the accounting standards. So that's a quick summary of the fraud triangle itself. So now I'll turn to applying the fraud triangle to tax evasion. So first, the fraud triangle has been extended widely, and some argue too far. It can be applied to many types of wrongdoing or quote unquote compromise, such as student plagiarism, the VW scandal, Bernie Madoff, etc. But tax evasion is not a big stretch. It's a type of fraud, and the fraud triangle often focuses on an individual acting alone, but doesn't always, and that's true of tax evasion too. Tax evasion can also be analogized to embezzlement, according to an article accountants Tackett et al. Published in Tax Notes. So let's go through the factors and look at how they fit with tax evasion. So first, incentive or pressure. Tax evasion always involves a financial incentive. That's true for tax evasion by individuals or entities for any type of tax. It sometimes also involves financial pressure. For example, small businesses may fail to pay over so-called trust fund taxes, which are withholdings from employees' paychecks, in order to keep afloat. An individual who owes money at tax time may feel financial pressure. But even an individual who's getting a refund still has a financial incentive to cheat. Corporate tax evasion is more complicated, but may involve pressure to keep effective tax rate low, keep the company's stock price up, et cetera, which can translate in turn to pressure on employees. So that's the first prong. Opportunity is very important, and it's the common element in all of the three factor studies, as you saw. If opportunity is not present, fraud is impossible, Tackett et al. Say. And similarly, without an opportunity to evade tax, tax evasion is impossible. But opportunities to evade vary across types of income. So compare, for example, the visibility to the government of cash receipts with no paper trail, which are very susceptible to evasion, with amounts subject to third-party reporting like a W-2 or 1099 form, which are hard to evade due to their high visibility to the government. Statistics show that third-party information and reporting do a lot of the work in U.S. tax compliance. So this on the slide is an IRS bar graph from September 2019, to which I added the words in red. And what you can see is that on the left, wages and salaries where there's withholding and a W-2 have virtually no non-compliance according to IRS estimates. And as the completeness of information reporting decreases, non-compliance increases. So on the right, there's high non-compliance where there's no information reporting or withholding. And on the next slide, I've just flipped around the figures to focus on compliance, not non-compliance. So for example, amounts that are subject to substantial information reporting, but no withholding, the IRS estimates a 95% voluntary compliance rate for, meaning 95% of the dollars are timely paid without any enforcement action. By contrast, where you have little or no information reporting, such as small business income, because customers aren't required to fill out 1099 or other information reporting forms, there's only a 45% voluntary compliance rate. So compliance, the IRS estimates to be much lower when income is not visible to the government, which I think is intuitive. And then turning to the third fraud triangle factor, that's rationalization. So according to Donald Cressy, the potential trust violator defines the relationship between the problem and the illegal solution in language which enables him to look upon trust violation, A, as essentially non-criminal, B, as justified, or C, as part of a general irresponsibility for which he's not completely accountable. And Vicus and Anand et al. Identified several rationalizations that they believe are most commonly used in organizations as justifications for corrupt behaviors. There's a line of literature on these rationalizations. Anand et al. Grouped them into 6 categories, such as denial of injury, no one was actually harmed by my behavior, or denial of victim, the injured party deserved it, as a couple of examples. And in the tax evasion context, Tackett et al. In their tax notes article argue that the overwhelming rationalization used for tax evasion is lack of equity in the tax system. And they argue that it manifests itself along 3 dimensions: uneven tax burden, fiscal irresponsibility by the government, and lack of enforcement. So I nicknamed these self-help, creating one's own tax break, and eye for an eye, the type of justification that points to government wastefulness or corruption, and refusal to be a chump, which focuses on the zero-sum game aspect of tax paying, because in general, tax evasion raises the tax cost for everyone else. And taxpayers may, of course, use other rationalizations as well. They may rationalize something along the lines of, well, I need the money more than the government does, or the government will never miss the money, or I overpaid in a previous year and this will right that wrong, as just some examples. Now, let's turn to the implications for tax compliance theory. And in my article, I use the fraud triangle as something of an umbrella to help bridge competing theories of tax compliance. And this is perhaps the most important contribution of the article. So prongs 1 and 2 of the fraud triangle fit nicely with the standard economic deterrence model. Prong 1 is incentive or pressure, remember, and incentive is an economic notion, so it fits very well with the deterrence model. The idea is that the possibility of paying less tax provides a financial incentive to cheat. And in real life audit and penalty environments, the expected cost of evasion is less than the cost of compliance. This is well known in the tax compliance literature. Prong 2 of the fraud triangle, again, is opportunity, and critics of the deterrence model often seem to miss the importance of opportunity to evade, and I've mentioned this in some of my previous articles. So here's what I mean. Some scholars, including some US economists and law professors, have said that voluntary compliance is a puzzle. The reason for that is that the prediction of the basic economic deterrence model of tax compliance predicts zero compliance given real world low audit and penalty rates. And that contrasts with the relatively high level of voluntary compliance in countries like the US. So this has become something of a standard way to start a tax compliance article that looks at non-deterrence factors as predictors of tax compliance. It's become somewhat standard to reject the deterrence model. But this simple comparison is incomplete. It ignores important aspects of deterrence, one of which is opportunity. Third-party reporting and withholding, as I've mentioned, both reduce the opportunity to evade, and they help explain this blended 83.6% voluntary compliance figure that the IRS estimates. Now, why is information reporting like a 1099 so effective? The reason is that third parties do not have the same disincentive to comply with reporting requirements because they're not paying the taxes, and penalties for failing to report encourage them to do it. And if a taxpayer is going to gamble about the prospect of being caught, perceiving higher odds of detection should reduce the likelihood of taking that gamble. So it's analogous to a red light camera. The taxpayer sees that the government will get the information, and that deters breaking the law. And now with respect to prong 3 of the fraud triangle, rationalization, that focuses on psychological aspects, which fits with behavioral economics theories, which are the theories that compete with the deterrence model in the tax compliance literature. So I mentioned 2 in the paper, 2 behavioral theories: norms of compliance or non-compliance. And some studies do show that appeals to compliance norms have at least a modest positive effect on tax payments. And connecting this with rationalization, community norms of compliance may make it harder for a taxpayer to justify evasion on the basis of rationalization, such as everyone does it, or it's not really wrong. And then conversely, non-compliance norms may facilitate rationalizations that the violation is not so bad or required so as not to be the only chump. And the other topic I discuss under prong 3, rationalization, involves taxpayer views of government. So John Schultz, a political scientist, has advanced a contractarian theory of government. And similarly, economists Lars Feld and Bruno Frey argue that there's the psychological tax contract. And in many articles, Frey, sometimes with co-authors, has argued that tax morale, which is the intrinsic motivation to pay taxes, is based on trust in government. And they've argued that enforcement may so-called crowd out motivations to comply, reducing compliance. But Joshua Rosenberg, a psychologist and law professor, has pointed to the separation in time of the benefits and burdens of taxes. So they're less linked in taxpayers' perception. Failing to pay taxes, in other words, may have nothing to do with dissatisfaction with the benefits received from government. So what should we make of all this? Well, certainly the government should treat taxpayers fairly. There's some evidence that procedural fairness may increase tax compliance, and regardless, it's the right thing to do. Taxpayers don't seem to act as pure contractarians in a relationship with the government. So for example, moral suasion letters pointing to the benefits obtained with taxation, like schools and snow removal, generally seem to have no effect on tax paying behavior, while by contrast, letters highlighting the audit rate or even compliance norms do have a positive effect. And I mentioned that Bruno Frey and his co-authors argue that enforcement may crowd out intrinsic motivations to comply, potentially reducing compliance. And in a 2018 article, I rebutted that line of argument. Enforcement does not decrease compliance, it increases it. And Rosenberg's 1996 article makes an interesting psychological point. He says, quote, "At least a part of the reason we do not comply more fully with the tax laws is that we believe either taxes specifically or government in general is unfair. Also true, however, is exactly the opposite. An important reason we believe tax laws are unfair is that we do not comply more fully with those laws," unquote. So if he's right, the causality here may run in both directions. So in conclusion, the fraud triangle is a theory that originated in interviews and case studies of embezzlers, but it's evolved through studies of accounting fraud. The factors have evolved too and have changed to fit fraud. The theory is largely absent from the legal and the economics literatures on tax compliance, but I argue that it provides a useful lens on tax evasion, and in particular provides a framework that suggests that deterrence and behavioral factors are both relevant to tax enforcement, serving as something of an umbrella theory. Thank you.
Thank you so much for that. I haven't taught criminal law for a number of years, though I used to, and feels like the kind of stuff I really enjoyed a lot, and I should have known more about, and I'm going to follow up more on and learn more about this, because I do find the concept of punishment and the resultant behavior modification fascinating. My father was a academic psychologist throughout his career. He and I actually published a couple of articles together talking about things related to this, not exactly on your point, but I find it fascinating. I really enjoyed the paper for that reason.
Thank you.
We will move to and then our third and final presentation. So Jamie MacLeod, if you go ahead.
Thank you very much to SEALS and especially to the Call for Papers Award Selection Committee. I was very honored to get this award and to be in such good company, especially after hearing these interesting presentations, both by Andrew and Leandra. Learned a lot, and it's a fun sort of set of 3 papers. Hopefully I can contribute to some of the fun, but it's a diverse set of papers and an interesting one. So my paper is about textualism in statutory interpretation, and sort of by extension, originalism in constitutional interpretation, but I'm going to kind of leave that to the side here, as I do for the most part in the paper anyway. We've all kind of read plenty of Supreme Court decisions where, especially lately, where one group of justices says that the plain ordinary meaning of the statute is X, and another group in the dissent claims that the plain ordinary meaning of the statute is obviously not X. It's something else that contradicts the majority. But it's a bit of a puzzle, at least if you don't sort of jump to accusations of bad faith or results-oriented judging or whatever thing textualists try to avoid. If you don't jump to those sorts of explanations, it's a bit of a puzzle what's going on. After all, textualism is supposed to reduce judicial discretion and promote consensus. So what's happening? Why does this happen so frequently that judges are left disagreeing with each other while applying this method that's supposed to reduce disagreement? The paper gives sort of two explanations. And just briefly at the outset, I'll say, and we'll certainly return to them, but the first is that judges and scholars too are not consulting particularly good evidence, particularly probative evidence of original public meaning or ordinary meaning or plain meaning. The second is that even if they were to consult better evidence, they also disagree about what they're looking for evidence of in the first place. And so we'll explore these two explanations, sort of the lack of good evidence and the lack of agreement about what they're looking for evidence of as we proceed. But first, I want to say a bit about textualism. So the idea here, and it shares this with constitutional originalism, the idea is that the original public meaning of the text dictates the results of the case. So original public meaning, or what again I'll refer to sometimes as ordinary meaning or sort of common sense everyday meaning, it tracks the answer to this question: how would the ordinary reader have understood the words of the statute at the time of its enactment? That's sort of a working definition of original public meaning that is pervasive in the literature and in the judging. People say, we're just going with how ordinary folk, if they were paying attention and if they understood the English language well, what they would have understood the text to mean. And textualist scholars say this is an empirical question. Scholars and judges often say that original public meaning is clear, and so it fully decides the case. That's all we needed to know. We just needed to know the ordinary meaning of this term. Look, it's clear, so now we have our resolution of the case. But again, textualists often disagree with each other. So the paper takes this example throughout. Bostock, this case that was sort of a blockbuster case in 2020. Title VII, under Title VII, when an employer discriminates against an employee because of their sexual orientation or their being transgender, does the employer thereby discriminate because of the employee's sex, or what everybody in the litigation assumed meant biological sex? Or to use a different phrase added to the statute in 1991, was the employee's biological sex a motivating factor in the employer's decision? So in the actual case, the majority via Justice Gorsuch says yes. And he goes on to say, no ambiguity exists about how Title VII's terms apply to the facts before us. It's totally unambiguous. It's just perfectly clear that the ordinary public meaning of this prohibition on discrimination because of sex encompasses the prohibition on discrimination because of sexual orientation and because of transgender status. But lo and behold, we've got two dissenters here, Justice Alito, who says, no, no, no. The plain text indisputably contradicts the majority's interpretation. A more brazen abuse of our authority to interpret statutes is hard to recall. And then Kavanaugh sounds sort of similar alarms. On occasion, he says it can be tough to assess ordinary meaning, but not here. Here, the majority has unilaterally rewritten American vocabulary and American law. So The first explanation for this sort of disagreement that I'm sort of exploring is, maybe people aren't consulting the most probative evidence. Maybe there's more probative evidence of ordinary meaning out there. So typically, judges and scholars alike consult their own intuitions as users of the English language. They consult dictionary definitions. And more recently, they consult corpus linguistics analyses, where a corpus of texts is mined for examples of the term or word in question. And then you sort of see how often it's used in a particular way as opposed to another way. If it's used more frequently in this one way, then that's the ordinary meaning. That's sort of the newest, most kind of teched up way of finding ordinary meaning. And all three of these are used in various opinions in the Bostock decision, but I want to propose that we can find better evidence of original public meaning using survey-based experiments. So this is sort of, to step back a moment, this is sort of part of a larger project, a larger movement called experimental jurisprudence. The idea is to use kind of the methods of experimental psychology and cognitive science to answer questions that are often seen as in the domain of legal philosophers or legal theorists. So I wanted to design some experiments to see how people understood the concept of causation and the terms because of motivating factor as applied here. So what does this mean to set up these experiments to see how ordinary folk actually interpret the relevant terms? Well, here's how the experiments were set up. Respondents in each of the three main experiments read a short vignette like this, describing an instance of employment discrimination. So here I have the sexual orientation discrimination vignette. There was also a transgender vignette that was very similar. And the third sort of main vignette, there was a fourth that I won't get into, but the third one was based on this famous Price Waterhouse decision from 1989. It was sort of about more traditional gender roles. But I'll just focus on the ones at issue in the Bostock case here, sexual orientation and transgender discrimination. Basically, people read a short story like this, and then they answered a bunch of questions, some of which were questions like, did so-and-so fire so-and-so because of so-and-so's sex? And they were asked to apply this definition of sex that just said, we're talking biological sex, male or female. Okay, and so the question is, how are most people going to understand and apply the statutory language to a set of facts? Here are the results of the motivating factor language, right? So remember, the statute had this because of language and motivating factor language. Well, pretty overwhelmingly, people in all three of these main conditions said, yeah, employees' sex was a motivating factor in the employer's decision to fire the employee. Here we have the sexual orientation results, significantly higher for transgender, and then this more sort of traditional gender stereotyping over here, which was just sort of a baseline comparison. And here are the because of results, that other key phrase in the statute. Again, at least somewhat of a majority, 60% said yes, the employee was fired because of the employee's biological sex. Significantly higher in the transgender setting, despite people in the sample and in society at large having less favorable views toward protection of transgender employees in the workplace from discrimination. So, there are sort of the basic top line results. Most people said, the plain language encompassed each type of discrimination that was tested. So it looks like the Bostock majority, right, Justice Gorsuch was sort of right as a matter of textualist interpretation. So the broader conclusion that I'm more interested in is this more general one: experimental evidence can help find original public meaning. But now I want to just briefly turn to a second conclusion. So the first one has to do with, consulting the best evidence we can of how ordinary readers understand or would have understood at the time the language at issue. The second conclusion has to do with this idea that maybe interpreters are not even agreeing on what they're looking for evidence of in the first place. That is, they have different conceptions of original public meaning. And so this conclusion number 2 that I'm going to discuss and kind of build up to a little bit, the idea here is the very method of designing an experiment like this, or at least thinking through what you'd have to do to design an experiment like this, reveals some problems with textualism. And so let's explore those. So again, this concerns, what is original public meaning? What do we mean when we say we're looking for how ordinary readers would have understood the language in question? Well, there are 2 pretty big ambiguities, I argue in the paper, that everyone seems to be glossing over when they argue about the ordinary, plain, everyday meaning of the text. And once you sort of see these ambiguities, I argue, they're examples of them that appear throughout textualist decision-making and throughout even scholarship by, the most careful textualists, and even critics of textualism who are saying, you textualists are being hypocrites because you reached the following conclusion, but really the true original public meaning of the text is this other thing. So you must be hypocrites. You're just doing results-oriented judging. Well, to even lodge that accusation, you have to have some read on what the actual original public meaning is, right? And so textualists and critics of textualism are often kind of talking past one another when they're arguing about original public meaning, because this way that they operationalize it, right, figuring out how ordinary readers would have understood something, has these ambiguities within it. What are they? Well, the first can sort of be thought of as what form of question would reveal the reader's relevant understanding. So I differentiate between what I call applied understandings, which are the sort that I elicited via the experiments that I ran, right? You could think, using Hart's no vehicles in the park example, an applied question would be like, is a baby stroller a vehicle? Whereas there are various types of abstract understandings, but one might be, you could just ask, name a type of vehicle, and then you only accept their first few responses. That'll get you a narrower construal of the regular language, and narrower in a very specific kind of way. There are other ways to elicit narrower understandings, but the question is, like, how, if you were trying to figure out the relevant kind of understanding, what kind of question would you want people to answer? That's one ambiguity. The second ambiguity is, well, when they answer it, what extra textual considerations, if any, would the reader properly deem relevant, right? Are they considering the consequences of their interpretation? Are they considering what the public expects, how the public expects the statute to be interpreted, and so on? So let me just sort of conclude here with a lot of text on the slide. Apologies for that. But the basic idea that this paper is getting at is, look, textualists are asking, right? Their crucial question is, how would ordinary readers have understood the statute's language at the time of its enactment? And they routinely claim, as do many of their critics, to have found the obviously correct answer. But they never actually ask ordinary readers. And so I tried doing that via these experiments. And I found, I think, interesting results if you're interested in the Bostock decision, but I'm less interested in sort of getting ironclad evidence that one or another side was right. I'm less interested in that than just sort of exploring what it would mean to take textualists' claims seriously, and to sort of see them through with the best evidence. So they never systematically ask ordinary readers. That seems problematic. They're not consulting the best evidence that they often could obtain. And if they did try to ask ordinary readers, or if they even just sort of thought through what it would take to elicit the answers from ordinary readers, then they'd confront some serious ambiguities about what reader understanding means, and therefore about what they're even looking for evidence of, what they're actually disagreeing about, right? When they disagree about original public meaning, when they disagree about ordinary meaning. So the sort of bottom line claim is textualist theory, right? Not some mistake in textualist practice, not some results-oriented, diversion from proper textualist practice, but rather textualist theory itself currently allows interpreters to choose either outcome in a whole lot of cases, including a lot of cases where textualists, pound the table and say, we have the one true answer. It actually admits of the plaintiff's interpretation and the defendant's interpretation in a lot of cases. And if textualists are really serious about finding original public meaning, then they ought to commit ex ante to what they mean by ordinary reader understanding. And I think that means sort of answering these two questions. They ought to commit to some answer to those two questions. And also, they ought to then consult experimental evidence, that is, evidence based on survey experiments where ordinary readers are actually asked what they think, wherever possible. And I argue that that's certainly possible with everyday terms like because of, and with recently passed statutes. And it's even possible with respect to statutes passed 60 years ago, at least in some circumstances. I think Bostock is one of those circumstances. If you supply the relevant information and only the relevant information, you supply the stipulated definition of sex and so forth, and then ask people whether it applies to the facts at issue. And so those are my conclusions. Thanks, everyone.
Well, thank you, Jamie. That's great. And it's obviously such an important constitutional issue that does divide the court and divide people over politics and such. And maybe if we can find some way to bring in actual evidence to support things one way or the other, that'll help out a lot. So we certainly appreciate your article. Congratulations again, and thanks, everybody.
Thanks
Take
so
care.
much.
Putting your students on the path to success starts with making sure they have the skills that are required to do well in your program. The GRE program is committed to helping you select a qualified and diverse applicant pool by providing a measure of academic readiness. The GRE General Test is an admissions test used by thousands of graduate, business, and law schools to assess skills that are fundamental for program success. These include critical thinking, verbal and quantitative reasoning, and analytical writing skills. And as a common objective measure, GRE scores can help programs fairly compare applicants from different backgrounds. Welcoming GRE scores without preference can help you attract more applicants to your program because the test provides students with convenience, test-friendly features, and flexibility not offered by the competition. And applicants can apply to graduate school, business school, law school, or dual degree programs, saving them time and money. More than 500,000 individuals take the GRE General Test every year, offering you the opportunity to expand your applicant pool. The GRE pipeline also offers your program the opportunity to diversify, as it provides access to applicants with broader interests and backgrounds, including science, technology, engineering, and mathematics. Also, more than half of GRE test takers are women. The GRE program provides institutions that accept GRE scores with numerous resources and tools, including online access to scores, test taker photos, and actual analytical writing essay responses, as well as access to test taker demographic and performance information to provide you a fuller context when comparing the qualifications of applicants with different educational and cultural backgrounds. The GRE program also helps you identify and reach applicants who will be a good fit for your program, provides online resources to help you understand and use the GRE scores you receive, and helps you guide and prepare your students, putting you and your students on the path to success. Rooted in the mission of nonprofit ETS to help advance equity in education for all people, the GRE program is committed to giving you confidence in your admissions decisions by providing fair and valid assessments backed by extensive research and other critical tools for success. For more information about the GRE General Test and services, visit the GRE website.